Good morning, this is John Lynch with another one of our COVID-19 videos. This morning I'd like to talk to you about agreements, or in particular co-ownership agreements, cohabitation agreements. These two agreements were possibly the subject of a recent case, or rather their absence would be more accurately described as the subject matter of a recent High Court judgment delivered on the 1st of April. Now, the case involved a couple who were actually living together, and during the course of living together, well, at the early stages, they bought a house. They put the house into joint names. Now, we all know, or rather most practitioners will know who are involved in conveyancing, that when you put a property into joint names, you can either put it into what they call joint tenancy or tenancy in common. Now, without getting too technical about it, in one case, the survivor takes all. In other words, whoever survives will own the entire asset. In the other case, both parties, or whoever, any number of parties you're talking about, will have a share in the asset. The effect of that means that each one of them will continue to own a share which they can pass on to, or sell to, or will to whoever they wish. This recent case involved a kind of an overlap in the whole area of the cohabitation agreements as well, because the couple lived together as a couple. They probably would have complied with the cohabitation criteria. They had a child, they lived together for longer than 5 years, and the relationship broke up. Now, for some reason, the case wasn't decided on the Cohabitation Act 2010, because on the face of it, now the judge commented on this, on the face of it, they would have had the criteria. They were in a committed and intimate relationship, they were living together, they had a child, they were living together for more than the 2 years, and the relationship had broken up. So one might assume that one of the two reasons why the Act didn't apply was that they separated in 2015 and the case didn't come on until 2020. And the criteria under the legislation is that you have 2 years from the date of the end of the relationship, or the end of living together, within which to take your case or make your claim to the court. The other criteria is that you have to be financially dependent on the party against whom you're looking for some form of redress. And maybe that didn't apply in this case either. But anyway, leaving that supposition or supposing aside for a second, the other area that would kind of jump out at you is that there was no form of agreement done by them, either to deal with the fact that they were living together, or which would be a cohabitance agreement, or there was no co-ownership agreement. So at no stage during the relationship did they formalise and document how the asset, in this case the home, was to be dealt with in the event of a breakup of the relationship. That then left the court to deal with the argument between the parties, which was that one of the parties argued that they had made a greater contribution to the asset and therefore should have the larger share on the sale of the asset. They were basing that on financial contributions that they had made out of inheritance, that they had the larger salary, they were making the greater mortgage payment, that they had paid an extra amount of money at the time of the purchase. So therefore, on that basis, their argument that there should have been something like an 80-20 split. The other parties argued the case on the basis that they'd bought the house, put it into joint names, they'd made a will leaving it to each other. They had joint bank accounts, everything was operated out of joint bank accounts. Both of them had received inheritance, both of them had contributed part of that inheritance to either the upkeep of the house or building on an extension or buying a car, which both of them shared during the course of their relationship. In fact, one of them didn't drive, which made for a very good argument on that front. And on that basis, the argument was that the intention of the parties was that this asset should be divided 50-50 between them, and there shouldn't be a kind of a contribution type of argument made. The judge dealt with the whole area of discretionary trusts and proprietary estoppel, in fact promissory estoppel. Didn't dwell too much on promissory estoppel, which would be the argument being that one party considered that they had a promise of a 50-50 split on the asset. The other argument was discretionary trust, resulting trust, whether there was a trust or whether there wasn't. In fact, what the judge came down to at the end of it was he considered that the clear intention of the parties in the context of a trust was that it should be 50-50, and therefore he made the decision toward them 50-50. The comment that you'd have to make, of course, is that how much did all that cost them from both a financial and emotional point of view to get that particular decision. The other thing that you might be asking yourself is, why was this not mediated? When you look at the emotional fallout that could possibly have arisen as a result, they had a son in common, and whether that might have impacted on that relationship. But the main reason that I find that the case is interesting is because of the lack of those two fundamental agreements, which is the co-ownership agreement, number one, and the cohabitation agreement, number two. I know that we say all the time as lawyers that if you just committed to writing, that you have a better chance, not an absolute chance obviously, but you have a better chance of ensuring that there isn't a fight afterwards or a disagreement afterwards, or at least that you have the mechanism whereby you can resolve the disagreement if the agreement is well drafted or suitably drafted or clearly drafted, because after all, we're all subject to an argument at the end of the day that an agreement may not be clear or the agreement may not cover. But again, I think I digress. That's not the fundamental point that I'm making. The point that I'm making is there should be an agreement, and it's not a difficult thing to do either a cohabitation agreement and or do a co-ownership agreement. And I think in all conveyancing transactions, a co-ownership agreement where more than one person is buying property should be considered. There's a second agreement that kind of surfaces when you're looking at cohabitation agreements and when you're looking at co-ownership agreements, and that is a separation agreement. And I leave aside prenuptial agreements for a second. And just a very quick word on separation agreements and the impact of those. I think it's probably fair to say that separation agreements now are not as prevalent or as common as they used to be, on the basis that a divorce with the 2-year period now within which you can get your divorce is going to fast track the whole process of relationship breakup, and the need for a separation agreement wouldn't be as high as it might have been prior to divorce or prior to judicial separation, or in fact prior to the 2-year period. But the kind of last remaining question, or one of the remaining questions that arises when you're dealing with separation agreements, is the question of whether the court will revisit the circumstances of the parties where a divorce has been applied for and there is an agreement, a separation agreement in place. It's somewhat similar to having a cohabitation agreement in place and somewhat akin to having a prenuptial agreement in place. The answer is probably somewhere in the middle, insofar as the court won't disregard the separation agreement and at the same time will take account of the separation agreement. But the overriding principle will always be that they will look to make and ensure that there is proper provision for all of the parties in the breakup. It was the case over a number of years that it was almost a given that the court would revisit separation agreements, judicial separations, and reconfigure the agreement that was made at the time. The Supreme Court has kind of put a stop to that, insofar as the Supreme Court has now said that divorce isn't a question of dividing assets or dividing wealth, it's a question of proper provision. And the issue of proper provision is retained by the court and they must make that decision. So the short answer is, if the separation agreement is not a very fair one, if it doesn't accurately reflect the asset basis of the parties, and if it doesn't make proper provision for one of the parties to the agreement, then the court will take it into account and may vary the orders or the agreement that was made. Thank you again for listening to me. This is John Lynch of Lynch Solicitors during the COVID lockdown. Thank you very much. Again, if you want to see any of our videos, we're on YouTube. We have a YouTube channel, Lynch Solicitors, and we also have a website, lynchsolicitors.ie. Again, thank you very much.